All right. Hello, everyone, and thank you so much for joining the Sierra Club Iowa chapter for our weekly Lunch and Learn. Every Friday at noon, we go live with an environmentally focused topic, bringing in experts and advocates to share their knowledge and insights. Today, we will be getting an update on the judicial review of Summit CO2 pipeline permits from Wally Taylor. He is the Conservation Chair and Legal Chair of the Iowa Sierra Club. He has practiced environmental law for over 40 years and brings deep expertise on legal strategies. And if you have any questions along the way, feel free to put them in the chat box and we'll go over them at the end. But with that, I will hand it over to you, Wally.
Okay, thank you. And we'll share your screen here. Okay, so let's go to the next slide. As a bit of background, uh, we probably all know what's been happening, that Summit Carbon Solutions has proposed to construct almost an 800-mile pipeline through 29 counties in Iowa um, in order to capture carbon dioxide from, I think it's 31 methanol plants now, and ship that carbon dioxide to North Dakota, supposedly to be simply buried there. The Sierra Club has opposed that project for a number of reasons, and we had in 2023 a lengthy hearing in front of the Iowa Utilities Commission, which has the authority to grant or not grant Summit a permit to construct that pipeline and to use eminent domain to acquire easements, even if the property owner doesn't want to give up that easement. So in June of 2024, the commission granted Summit a permit to build a pipeline along with the right to use eminent domain. We intervened in that proceeding. As I said, we had a lengthy hearing, and all sides presented evidence that the commission was supposed to look at and consider and make a decision based on that evidence. But the commission ruled in favor of Summit, granting a permit and granting eminent domain. So the legal procedure after losing in the commission process is to go to district court on a request for judicial review. And so all the parties who opposed the pipeline have done that. We filed our petitions in district court, and that process is now proceeding. So let's go to the next slide. What we've done so far is file written arguments that are called briefs. All of those briefs have now been filed, and the basis of our appeal to the district court is that the commission's decision made a number of incorrect interpretations of the law, that the decision was irrational in many respects, that the commission did not consider relevant evidence that they should have considered, and they made unjustifiable applications of law to the facts. In other words, the law requires, what the Summit must show and what is required for a permit, and the commission has to apply the facts to that law. They can't just make whatever factual determinations they want. And furthermore, that the commission's decision was arbitrary, capricious, unreasonable, and an abuse of discretion. That's a lot of words for saying that the decision was simply off base and made no sense. And we've alleged these bases for our appeal because those are set out in the Administrative Procedure Act. There's also another um, basis on which a, uh, uh, a decision can be overruled by the court, and that's if the decision was not based on substantial evidence. But that's a pretty low bar for the commission to jump over, and it allows the commission to argue that, well, you can't just um, argue that you don't agree with our interpretation of the facts. Well, we're not saying that. We're saying the commission went beyond just an incorrect view of the facts. We're saying that they just really um, went beyond that and made a decision they had absolutely no basis in the law to issue. So we and other parties, impacted landowners, several counties, even some Republican legislators um, intervened and made similar arguments. Uh, all of the final briefs are being filed today, um, and the Summit and its supporters, we feel, made a pretty weak argument, um, essentially telling the court, as I said, that the court must give deference to the commission decision. There were a number of issues that were presented. Um, First of all, the commission had to find, in order to grant a permit, that Summit and its project promoted public convenience and necessity. Now, that's a term that does not have a real clear definition, but from looking at Iowa Supreme Court cases over the years, it means that there has to be some service provided to the public in order to justify granting a permit for a project like this. Now, the Utilities Commission said, first of all, that the tax credit, the federal tax credit, it's called a 45Q tax credit, that Summit is seeking for its project was the overriding basis on which the commission felt that there was public convenience and necessity provided by this project. But we pointed out that you have to look at how tax policy is made. The commission said, well, if Congress approved this tax credit, that must mean that it serves the public. Well, we pointed out that tax policy is made by lobbyists and campaign contributions, not the common good. So we think that the commission was off base there. Additionally, Summit was claiming that, in their view, the overriding purpose of this project was to promote the ethanol industry, claiming that that benefits the entire state of Iowa. Well, if you look at what's going on here, really the only benefit to ethanol was to the ethanol industry by another tax credit that the ethanol industry would get by producing what they claim is clean ethanol because of the carbon dioxide being removed from the process. But actually, the expert that Summit presented for the ethanol industry was the CEO of an ethanol plant in Hardin County. And when we took his deposition, he had to admit that really there was no overall benefit, that the ethanol industry didn't really need this pipeline and this carbon capture in order to keep on going and keep making money. They just want to make more money. So really and they had to admit that, there are pros and cons to the ethanol industry, particularly in terms of farmers. If the corn that's used for the ethanol if the price increases, that hurts the livestock industry because they have to pay more for the feed that they feed the livestock. So it's just a real house of cards as far as the ethanol industry is concerned. Another sort of interesting argument by Summit was that the pipeline was safe and therefore was a benefit and promoted public convenience and necessity. But at the same time, they were saying that, and most of their witnesses talked about the safety of the pipeline. But at the same time, Summit is claiming that federal law preempts the Utilities Commission from considering safety, saying that a federal agency called the Public Hazardous Materials and Safety Administration, I think I got that right, PHMSA for short, regulates safety standards on pipelines, and therefore the Utilities Commission have no authority over the siting and routing of the pipeline. But the law is pretty clear, we think, that the Federal Pipeline Safety Act just addresses safety standards on the pipeline itself or the construction of the pipeline itself. And there's a specific section in the Pipeline Safety Act that says that it has no authority over siting and routing of the pipeline. But anyhow, the Utility Commission said that because of the safety considerations that they would approve the pipeline. It's kind of a side issue. I don't want to get too far afield here, but as a sideline, Summit sued several counties that had adopted ordinances setting out in terms of zoning where the pipeline could be sited and providing setbacks from certain structures and other locations where the pipeline might cause damage if there's a leak or a rupture. Well, the federal courts so far, even up to the Federal Court of Appeals, has agreed with Summit, curiously enough, in spite of what the Pipeline Safety Act clearly says, that the federal law does preempt the counties from adopting these ordinances. The counties are now saying they're going to go to the U.S. Supreme Court, and but the U.S. Supreme Court doesn't have to take every case, and so they may not take the case, but hopefully they do. In terms of eminent domain, we've argued that Summit has to be a common carrier in order to get eminent domain. And they're not a common carrier because they will capture the carbon dioxide themselves, and they will own the carbon dioxide and carry it to the Dakotas. Although they do have a problem because South Dakota, in more than one way, has said, no, you can't build your pipeline in South Dakota. So I don't know where they're going to, they think they're going to go with it. So we think that the commission improperly granted some eminent domain authority. We also argued, finally, that the Utility Commission denied us due process because of the way the hearings were conducted, the way that the pipeline opponents were treated differently throughout the proceeding, as opposed to Summit and its supporters, that we did not get a fair hearing or a fair fact finder in the Utility Commission. And that's a denial of due process. So for all of those reasons, we are hopeful that the district court will rule in our favor and invalidate the permit that the commission gave to Summit. But no matter which way um, the district court rules, the case will most assuredly be appealed to the Iowa Supreme Court, which means more written briefs, more argument, and a decision either affirming the district court judge or reversing the Polk County decision. If the decision affirms the district court affirms the permit to Summit, then we could look at going to the U.S. Supreme Court, whether we'd have grounds or not. I don't know at this point. Or we could go to back to the commission for further proceedings. So we'll have to see what happens. That we don't know what sort of time limit we're looking at. The district judge can take as much time as he wants, but the next slide, we go to the Supreme Court. They will take some time to enter a decision, and that it could take another year. So we're going to keep at this, and let's go to the next slide, if there is one. It, so that may be the last slide. Yep. So we will keep everybody informed, and at this point, if you have any questions, I'd be happy to answer them.
Thank you so much, Wally, and I apologize for my my off on the slideshow here. We do have one question. Is there anything that landowners or the general public can do at this time?
As far as, well, I probably should have explained that this appeal is regarding what we call phase one of Summit's a project, which they got the permit for last year. And there isn't much you can do on that at this point, although we're going to try to get a bill through the legislature again after it'll be the fourth year, I think, or fifth year we've tried to do that. After all the bad publicity that the legislature and the governor got this spring from vetoing a bill that did get through the legislature, we may have a better shot. Now, Summit also has proposed what we're calling phase two, which involves some ethanol plants that had contracted with another pipeline company called Navigator. And Navigator pulled out. They, for whatever reason, well, we think they couldn't get enough easements. But in this phase two, Summit also is having trouble getting easements. They only have about 12% of the easements they need. So if you go to the Iowa chapter website, there should be some information there about how you can submit comments to the Utility Commission, asking them to deny somebody a permit on this phase two. It just doesn't make any sense to even go any further when they can't get any more easements than that. And particularly when they can't go into South Dakota. So there should be, and you may be, our members and supporters may be getting a newsletter today or tomorrow giving information on that and how you can send in a comment or objection to the Utility Commission. So that's something you can do right now to hopefully stop phase two.
Awesome. Well, thank you so much, Wally, and I'll be sure to share the IUC information so that you can submit a comment for that. But thank you so much for talking with us and giving us this update. It was super informative. I appreciate it. Thank you so much, everybody, for tuning in. And if you have any questions, don't hesitate to put them in the comments and we'll make sure to get those answered for you afterwards. But thank you again. We'll see you next Friday. Bye, everybody.